mention emails and texts because it's a big deal. That's the sort of the forefront. A lot of states have amended their FOIAs already to update their laws to deal with these kind of electronic communications. We have not. And the last time our act was amended to deal with electronic records was in 2001. And they were great amendments, I mean, but they were even still behind the times when the Electronic Records Study Commission was put into place and studied how do we update our FOIA to deal with electronic, computerized records. Now it's way past time to deal with these records, and as a consequence, both on the, requesting end and the public body end who's handling records requests, a lot of questions come up, and there's a case percolating its way up, I think it's still on appeal, dealing with emails, and when public and private communications are sort of commingled, when's it going to meet the text? Because remember the definition? It has to be a record that constitutes, it has to reflect the performance or lack of performance of official functions. So we've got a few instances where public employees, there's some business going on, maybe with somebody in the private sector that the public's really interested in knowing. Was that contract, did that person properly get that public contract paid for with public funds? Was some undue influence come to bear? And then maybe they have a personal relationship involved, and we get these, as I say, commingled public-private, very fact-specific. You look at each email, and at some point a judge is just going to make the call, and it's going to go up an appeal on that record. That's the way cases get resolved. And all we lawyers can do is tell you what we think, what the court has said, what the legal test is for when an email or a text message is going to meet this definition of a public record. And there has to be a substantial nexus between the business activities and that email, reflecting a substantial public business. So once we decide it's a public record, here's the rule. It's got to be disclosed. I mean, the custodian has to disclose it unless some exemption applies. Exemptions can come into play either by state law, by federal law, but for the most part, once the determination is made that it's a public record, the custodian should be in the posture of, not searching for exemptions. I try to informally counsel people, because we spend a part of our time, believe me, taking phone calls on FOIA where the Attorney General cannot engage in the private practice of law. So it's kind of a fine line. We can't counsel people individually as lawyers. Sometimes that upsets people. Well, you're the public's lawyer, and she's the chief lawyer for the state. You're my lawyer. Well, we're the lawyer for the public generally, but not for people individially, if that makes sense. So she can get in trouble if she actually tried to counsel you as your lawyer. So Ray and I are really aware of that, and we try to speak generally about FOIA. We try to point people in the right direction. If we've done a previous AG's opinion on it, we try to get people there. I sometimes probably cross that line a little bit of trying to say, but I'm trying to make it clear. This is Beth Walker talking. I've dealt with FOIA a long time. I'm just saying I wouldn't want to stand in front of a circuit judge and make that argument, city attorney, that you're trying to make. I have those conversations a lot. Now, whether it makes those records be turned over or that meeting open, I don't know. But I'm very aware that once you're comfortable it's a public record and I hear people trying to pigeonhole something into an exemption, that's not a good place for that lawyer who's count to be, okay? The exemption, because once again, let's go back. Exemptions are narrowly construed. The act is interpreted in favor of openness, and exemptions are narrowly construed. So the exemption needs to be pretty darn clear to prevent that public record going out once it's determined it's a public record. But again, that's a record-by-record inquiry, okay? And sometimes there are lots of surrounding facts you have to take into account, even beyond just the face of that written record. So now, I've got a few minutes more here to talk to you about some of the mechanics about making a FOIA request. If you've done this before, you know it, you probably know the drill, but I thought it probably couldn't hurt to just mention, because I know we hear sometimes people call in and say, wow, this I was making a request at X, Y, and Z, maybe a police department somewhere, maybe a city clerk, and he or she was like, well, put that in writing. Do FOIA requests have to be in writing? No, absolutely not. And then I don't think you even have to use the term FOIA when you're making a FOIA request. I think it's a good thing to do, so you're on the same page. But now we're at the point of, we want a meeting of the minds between whoever you've presented your FOIA request to, okay, and you. You want that person to know, which is the custodian. That's the person that the agency, the city, government, body has told that department at the city or the county or that state agency who's in charge of our FOIA request. And we've done that in the AG's office, because obviously we get FOIA requests. And we've designated, it's our chief deputy, Julie Benefield, and she is our official records custodian for the office. So Ray and I and my team assist in responding to FOIA requests to the AG's office as well. But everything goes through Julie. We have a set, and everybody should do that out there. When we speak to government officials, we say, it's not encouraged, it's really required by the Act. The Act contemplates that you don't bounce people around. Well, I don't know who'd have that record here. We're a big agency, let me check. No, they're supposed to have done that at the front end, designating someone for you to go to immediately, who has administrative control of the records. And how you make the request, if they reasonably know you're looking for records, doesn't matter, fax, in writing, email, it doesn't matter, phone call. Here's the specificity part, and this is what I was mentioning about having a meeting of the minds. And this is, I put quotations here, because records requests are supposed to be sufficiently specific to enable the custodian to locate them with reasonable effort. That's in the language of the Act itself. And that oftentimes gives a custodian a basis to say, I just don't know what you're looking for. And frankly, we see fishing expeditions where somebody really doesn't know what they want. And we do see situations where people are just upset and they're submitting the same FOIA request to the same police department day in, day out, and they want like 10 years of records, and they're really it really is kind of a harassing thing. We see that, I have to be frank, we see it. We see the other side too, of agencies not sufficiently processing requests, maybe hiding a little bit behind this with reasonable effort, but you just got to know that's in the Act itself. And why is that? Well, it's because the FOIA Act, the Act says that records are to be made available immediately unless they're in active use or storage. And then it's what you probably know is called the 3 working day rule. We think for the most part, public records are in active use or storage. That's never been fleshed out in case law. But anybody asks me, I think we're beyond the point of a whole lot of serious debate about thinking that you should be able to walk into a public office and say, I want all your records for this period of time and I want them immediately. I mean, I just don't think any circuit judge, if you tried to go to court and they said, no, we're going to make our best effort in 3 working days. We know that's the time frame under the Act. I wouldn't jump and go to court over that right away. I think for the most part, it's 3 working days.